This is a lecture from my professional responsibility class. This lecture from my professional responsibility class is about Model Rule 2.1, lawyers as advisors. So this begins a new section for us of the model rules. I finished up advertising and solicitation. Please keep in mind for my students that we're now safely into the areas that are least tested on the MPRE. So when you're prepping for the MPRE, please, as a reminder, make sure you review thoroughly the conflicts of interest rules and the client-lawyer relation rules, 1.2, 1.3, 1.4, 1.5, and confidentiality. And but this is there will be a few questions on 2.1, 2.3, and 2.4 on the MPRE, and could sometimes on my exam, and so we're going to talk about them. Now, these rules generally, 2.1, 2.3, and 2.4 are about special rules where the lawyer is not providing what you might think of as traditional legal representation. So they're not litigating on behalf of someone as an advocate, and they're not drafting or handling their transactional work in the way you might normally think. But nevertheless, these are things that people need lawyers to do, and so we have special rules governing them. So first, our first rule is that when representing a client, a lawyer shall exercise independent professional judgment and render candid advice. Now, I'm going to stop right there. The first part of this we've seen repeatedly in the rules. We saw this in essentially in one of the 1.8 rules with third-party payers. We saw this again in 5.4, and now we're seeing it once again about the absolute importance of exercising independent professional judgment. In other words, that other people aren't telling you how to represent your client or going to trial. And this is also a rule for requiring candid advice. We've had something like this in 1.4, the communication rule. But here we're going to add something. In rendering advice, a lawyer may refer not only to law, but to other considerations, such as moral, economic, social, and political factors that may be relevant in the client's situation. So this is important, and if you think back for my students to the Alton-Logan video that we watched, that 60 minutes clip about the Alton-Logan case, and one of the issues that we address is whether the lawyers who knew that Alton-Logan was innocent and knew that their client was guilty could have tried to talk to their own client about coming forward and keeping Alton-Logan from being wrongfully convicted. And under 2.1, it's very clear that you are always allowed to talk to your client about the morality of what they're doing. And so it's a cop-out, in other words, for a lawyer to say, it's only my job to tell my client what to do that's in their legal best interest, and not to try to get them to do the thing that is a decent human being would do. And so it's always okay to give your client, talk to them about the moral angle of what they're doing, or to talk to them about the costs of what they're doing. And so, for example, 1.4 is pretty clear that you have to talk to a client about things that the client is going to have to pay you for. So if you're going to go hire jury consultants or really expensive medical experts or something, obviously you have to check with the client and talk to the client about that first. But there could be something else to think about, that the client could be pursuing something that's going to incur a lot of costs later on, or could impose costs on other people, or might turn out to be a huge waste of money, or maybe it becomes clear to you that your client really doesn't understand things like compounding interest rates or how the stock market works or currency rate fluctuations and so forth. So all of these are things that are okay for you to kind of involve in the discussion with your client. There's no rule against it. There's certainly no rule against it. Let's talk about the comments for Rule 2.1. The client is entitled to straightforward advice expressing the lawyer's honest assessment. So your client has a right to that. Legal advice often involves unpleasant facts and alternatives that the client may be disinclined to confront. And we talked about this earlier in the course a little bit when we talked about 1.4. That sometimes you are going to have to be the bearer of bad news to your client. You're going to have to tell your client something like, so it looks like we're going to lose. We're going to lose. Or a prospective client comes to you and wants you to bring a particular type of case, and you have to explain, there's no way we can win that, or that's really going to be a long shot. And sometimes you have to, you owe it to your client to give them kind of the stark, realistic picture so that they can make better decisions. And the rules warn you, and I'm going to warn you, that a lot of people don't like to hear the truth, right? They can't handle the truth. They want people to tell them what they want to hear. And this doesn't, by the way, necessarily even correlate to how successful the person is. There are very wealthy, powerful people who have spent too many years surrounding themselves with yes men or people who only tell them what they want to hear, and they have enough money that and influence or power, clout, that they continue to get by. But at some point, it can be catastrophic for them that everybody around them is basically telling them half-truths or hiding bad news from them. And as a lawyer, it's part of your job to tell people the good and the bad. Now, it keeps going with this. In presenting advice, a lawyer endeavors to sustain the client's morale and may put advice in as acceptable a form as honesty permits. Even so, the lawyer should not be deterred from giving candid advice by the prospect that the advice will be unpalatable to the client. So think about it. There are lawyers who really believe that you got to keep your client from giving up, or your client is depressed or worried and or freaking out, and you want to keep their morale up and encourage them a little bit, and that's okay as a lawyer, but not to the point where you're not being honest with them. And sometimes you're going to have to present things and give them candid advice that they may react negatively to. There are people whose response to bad news is to kind of shoot the messenger, to start yelling at the person or get angry with the person who told them the truth, or to start crying, or something else that you find unpleasant and don't want to deal with. So here's something that some lawyers will do as a coping mechanism, which is advice couched in narrow legal terms may be of little value to a client, especially where practical considerations such as cost or effects on other people are predominant. And purely technical advice, therefore, can sometimes be inadequate. So there are lawyers, sometimes when they have to tell their client something that the client's not going to like, who will switch to super technical terms. And so instead of saying, we're done, the judge dismissed the case, they'll say something like, the judge decided to grant the other party's 12b6 motion, or something like that. That is kind of, you're telling the client the truth technically, but you know that they're not going to understand, because you don't want to be there when they figure out what that means, because you don't want to deal with a big display of emotion or a confrontation or something. And so some lawyers, their coping mechanism for delivering bad news is to suddenly use highly technical language to sort of take a step back from things. And by the way, there's doctors who do this too. Their bedside manner, when they, even subconsciously, when they have to tell someone like, look, you have 3 months to live, you need to put your affairs in order, you're dying. They just can't get the words out, and because they don't like the emotion of the moment. So instead they start talking about, um, cell mitosis and mitochondria and cells dividing too rapidly and things like that, and immunodeficiencies, and start using really big words that trust me, once you've started talking about enzymes and things like that to your patient, their eyes have glazed over and they've stopped listening and they don't realize you've told them that they're dying. And so doctors can do this too. Lawyers have another trick, which is to switch into suddenly using archaic legal language. And so even if it's not technical, a lawyer who doesn't want to answer the question when all of a sudden they start using heretofore and wheretofore and whereas and stuff like that in normal speech, which no one does unless they're trying not to talk and trying not to communicate clearly. Oops, wow, really small print on that slide. I apologize for that. It's always proper to give relevant moral and ethical advice. So fortunately, even though I made the font on the slide needs to be fixed, I've already talked about this point. And so even though you are not a moral advisor as such, nobody expects you to be a moral philosopher or a minister or clergyman or something like that. That doesn't mean it's not a consideration and something that could be very relevant. A lot of legal questions impinge on moral considerations, like because you could hurt the other side, or we're talking about people's rights and feelings and future and things like that. And so we need to think about that. Now, some clients are going to ask for purely technical advice. And here, if you want an example, you should be thinking of in-house general counsel, and they've outsourced litigation to you, or they've brought you in as an expert on a particular type of legal matter, legal question, to consult with the company. And they may want you to, they're a very sophisticated client, they're a lawyer too, and they want you to give a simple technical answer, purely technical answer, like tell me, for example, the relevant statutes, or what does the legislative history say, or explain the circuit split on this question for me. And they're a lawyer, and you can just tell them that, and you don't have to couch it in anything, and you don't have to explain, well, you got to think about the big picture and the human side to this and so forth. And so if your client asks for that, if that's your client, you can take that at face value. On the other hand, if the person asking, the client telling you, just give me legal advice, if it's someone inexperienced in legal matters, you probably have a responsibility under the model rules to say there's more going on here than just the technical letter of the law and the strict legal answer. And so you should be aware of some of the consequences and some of the costs and some of the human element and so forth. So again, sophisticated client, in-house general counsel has outsourced something to you or brought you in to consult on a case. If they say, look, we didn't ask you for a sermon, just tell us the expert answer on this technical question, great. If this is somebody that you're only the first or the second lawyer they've ever hired in their life, they probably haven't had the opportunity or the experience to think through what happens with certain things. Also keep in mind that matters that go beyond strictly legal questions could be in the domain of another profession. And so let's say you're doing family law or unfamily law. And so that could bring in psychiatry, clinical psychology, social work. Business matters can involve problems within the competence of the accounting profession and so forth. And you are not expected to know all of that. Also, comment 5, you're not necessarily expected to give advice until asked by the client. And by the way, some of your clients are going to be rude and are going to say, when I want your advice, I'll ask for it, or something like that. And so if you have a client like that, don't give them advice that they don't ask for. Some of your clients are going to be frustrated that you're writing memos and letters to them and running up your legal bill on questions that they don't really care about. On the other hand, if you know that the client is proposing a course of action that is likely to result in substantial adverse legal consequences to the client, under 1.4, you have a duty to volunteer that advice. So normally you're representing a client, you don't have a duty to volunteer sort of unsolicited advice until they ask for it, unless you can tell that the client's about to drive off the cliff legally, right? That there's going to be consequences and that you're not sure they're aware of, and then you could be subject to discipline for not bringing that up and telling them. The second part of comment 5 is puzzling. When a matter is likely to involve litigation, it may be necessary under 1.4 to inform the client of forms of dispute resolution that might constitute reasonable alternatives to litigation. In other words, this seems to suggest that sometimes, but it only says may, there may be a legal duty to suggest ADR, like arbitration and mediation. And so let's put this another way. In real life, now we're not talking about a multiple choice exam question, but in real life, could a client file a grievance against you, and could you be subject to discipline from the state bar because you never told the client that maybe they should try mediation or arbitration in the case? Yes. Yeah, that's what this is saying, that there could be cases where that was so obvious and litigation was going to be was clearly pending, and this case was a great candidate for ADR, then it actually could be something that in hindsight looks like you should be subject to discipline for not mentioning the ADR option. Okay, next. You don't have a duty to do all sorts of like background investigation or look into your client in order to give advice that the client has indicated is unwanted. And so if the client calls you and they say, look, I need advice about my businesses or something, and you suspect that the client is also, I don't know, violating some other law, right? That they are trading in bald eagle feathers or something in exotic animals or something, and you're not in a TV show. You're not a TV show lawyer. You don't have to engage in a big old investigation on the side to figure out what your client is really up to about something that they didn't even hire you to give them advice about, so that you can protect their interests. On the other hand, you won't be subject to discipline if you do. If you notice something and hear about something, and it's apparent to you that the client is doing something that is going to have far-reaching legal consequences or serious legal consequences, you won't be subject to discipline for saying, by the way, I know you haven't asked me about this, but I want to bring something up that I'm a little concerned that I've heard you say or overheard or have noticed, and I just need to give you a heads up that there could be an issue. And the client may say, I didn't ask you, and then you back off. But if the client files a grievance, which is I've never seen, against a lawyer for offering advice that the client hadn't asked for, you won't be subject to discipline for that. If you need to document that you watched this lecture, our lecture attendance password for this rule is doctrinaire.